It's an honor to be here today. We're very excited to be hitting Jarbo, true friends on site up here. And this is the second Riley I get to debate in front of today, so I'm also excited for that. Joe and I think we have a pretty interesting case. We came up with it just this past week in preparation for that. What we're going to argue today is that we should have, in trials, we should have court-appointed non-adversarial experts. So this is people who give expert testimony, like medical experts, ballistics experts, should be appointed by a judge based on a list that we imagine some federal government agency should draw up. Salaries like hidden will be based on peer reviews from experts in the field. Do you guys have any questions before we get into it?
How is this substantially different from the status quo where you have a crime lab that doesn't work for the prosecutor's office but is still like there to provide this kind of evidence?
Well, so this would apply like what? So there would be no other experts meaningfully. So prosecutors and defendants wouldn't bring experts. The way we envision this is like either a prosecutor or a defense lawyer could go to the judge, request it, the judge would put in a request for an expert, and the expert would give testimony solely of their own accord. And this could be any sort of expert testimony.
Who decides what expert information is brought forth?
So the expert would be put on the stand, and both lawyers would be free to cross-examine the witness.
Right, but like what aspect, like say, who would decide whether the psychological status of the defendant is brought forth or not?
Right, so if it's deemed necessary by either side that psychological testimony from an expert is necessary, then we'll bring in the expert, put him on the stand, and either side can ask
So if the prosecution says we want it, or the defense says we want it, then we bring it.
Right.
Okay, and then what about like competing theories? What if they both need a different kind of psychology?
Oh, so you don't put in a request for like a psychologist who believes a particular thing. You just say we want to try out a psychologist.
Okay. All right.
And the requests are never, the requests are never denied. If the defense asks for it, you got it. And if the prosecution asks
pretty
for
much.
it,
There might be some like really nitpicky cases where you might want to deny it if it's like the 17th or whatever, but like, yeah, basically, yeah.
So they don't even have to provide any probative value. You just have to ask for like one.
We'll say that judges have ultimate discretion in this.
Okay, all right.
If you guys want to debate around the edges, come on.
And then get all the arguments out.
So are we good to go?
Go for it.
So we have two arguments for you here today. The first is that this is going to lead to more accurate verdicts. And I think the question we want to ask first is the adversarial system appropriate for judging competing expert claims? So why do we think the adversarial system is good in the legal system in general? Well, so this is the sort of theory behind a debate round, right? So we get two sides together who are pretty smart. They argue their case the best we can. Then we have an impartial third-party arbiter who decides which side is correct. But this is only effective if judges are able to evaluate meaningfully different claims. In debate rounds, it's judges. In courtroom, it's juries. Or it could be judges too, but usually going to be juries in this sort of thing. So the problem is you get what happens in a lot of IR rounds. This is why Joe and I don't run IR cases, where both sides just make competing factual assertions about the status of Chinese foreign relationships. Joe loves to do this because he's really into China. But the point here is that judges are oftentimes unable to evaluate meaningfully between competing theories here because they're just based on factual assertions. This is especially analogous to medical and ballistic analysis, when it just does come down to factual assertions that juries literally aren't going to understand the Krebs cycle. They're not going to understand Newtonian physics and why maybe JFK's bullet caused his head to move back and to the left instead of front and to the right. So juries are just unable to evaluate competing expert claims. So the adversarial system, Joe, and I think is just inappropriate for judging competing expert testimony. So we think that all this current status quo does is have experts blind juries with science. That is just make very, very haughty rhetoric of academia that sort of not necessarily going to be won on the facts, but rather just on confidence and the sort of things that my brother used to win debate rounds on, right? So the second argument we want to make under this idea of accurate verdicts, though, is we want to ask the question, what type of verdicts, what type of experts does this get you? Because Joe and I think that's actually going to get you experts with the most extreme simplistic views. I think that this current system is going to punish nuance, punish medium ground situations. You want someone who's going to support your case because you're hiring them as an advocate for your side. That is, you're going to get someone who is actually a young Earth creationist or something and says evolution has no factual grounding. And rather than and on the other side you can have someone who says intelligent design. Well, maybe that's a bad example because it probably does have no actual grounding. But one way or another, you're going to get someone who's just the most extreme views. We also think this is probably true because it's attorneys who have weak cases otherwise who are going to be most motivated to seek out expert testimony to bolster them. And I think that's when you're going to get the really left tail end of the expert field within whatever field you're talking about here. Go ahead, Trevor.
Okay, but what about people with new theories, or theories that aren't proving it, or ideas that you just haven't had time to like figure out whether or not they belong on the list. If someone's evidence is absolutely critical to proving that, say, a person was criminally insane at the time they committed a crime, but their theory isn't generally out there in in the ether, how do you get them in front of the court?
We don't, and we're perfectly fine with fighting that. If there's a theory that's like fringe and exciting, maybe string theory, but is not accepted by the scientific community writ large, we don't want juries making that decision. If the scientific community can evaluate the differences between string theory and Einsteinian, what is that word? I don't know. And Einstein's theory of relativity, then they're certainly not going to be able to evaluate any difference here in like sort of fringe views. I think what's much more likely is if you get someone there to get someone like string theory proves that this person did not shoot someone, juries might actually believe that, even though it's probably just a ridiculous claim. Alright, so alright, moving back to the argument of what type of experts do you get, I think there's a problem when experts are going to feel psychologically beholden to whoever calls them. This is true, so we think that experts are generally academics, they have some sort of, precepts of honesty. We're going to assume that they're in general good actors, or for most part. I think that you still feel psychologically beholden in your testimony to provide a particular viewpoint, even if you yourself think it's a complex issue. I think this is just simply because you're placed in the role of an advocate, and this is sort of a weird psychological argument we gave you for Zimbardo prison experiment argument, that you cede your rationality when you're placed in another role and you adopt the persona of that role. I think when experts are placed into the role of an expert, they might go override even their own opinions. But the next thing under this we tell you is that this is a difficult ethical position for experts to be in. So we think it's entirely possible that experts who have a lot of concern for ethical issues either won't be chosen or won't be willing to testify. So it might be a little more likely that you're going to get people who are sort of in the shady end of the academic pool. The last thing we tell you under this is that experts have incentives to signal political positions to ensure that they get hired in the future if the costs are great. So if I'm an expert on whether or not tobacco causes cancer, I have a lot of incentive to publish research that sort of hints at that I would be a very good expert to call for the tobacco lobby or something like that. The last argument we're going to give you, the sort of point C under the advocate verdict argument, if you want to title it that way, I don't really care, is that we think this gives too much credence, the status quo, to fringe views. Why is this? Well, I think when you just have two opposing views in the expert, it's hard to tell. You sort of assign them Bayesian equal priors, right? Because you have no basis for understanding ballistics or medicine or something like that. So if you assume that two sides are just sort of prior equal coming in, then it's entirely likely that one might be just totally fringe. So that is, if apparently Joe tells me that in child abuse cases, it's widely accepted fact that children have a lot of good reason not to come forward right away when they've been abused. But apparently there are some psychologists who are just very, very, very seriously saying, well, get up on the stand and say no, children will come forward immediately if they're abused. The problem is if you have one expert testifying one thing and one expert testifying another thing, if I'm just a jury member, I have no way of knowing that the scientific community writ large gives almost no credence to one particular theory or another. And one can make an argument nobody else in the scientific community believes this, but I think that's really hard to persuade the jury of this. I think that, and I'll take you in a second, Jarbo, that when you see lists posted online of the following scientists have problems with evolution, then people actually give some credence to that and they think there's still some controversy about evolution or climate change or whatever, pick your own issue. But really, there's almost absolute consensus within the scientific community. Go ahead, Jordan.
If this problem is so terrible and people are just so swayed by experts, then why is your system any better? Because if presumably people are just going to defer whatever the expert says, and no matter what a prosecutor asks, they're just going to defer to that, don't you exacerbate that problem by having only one expert?
So you only get a benefit by having two experts if we can meaningfully differentiate between the two experts. What we also tell you is that the one expert you get is going to be better than either of the two experts you get on their side of the house. Recognize on their side of the house it's a really sharp binary. You're either all the way this way or you're all the way this way. What you're going to get on our side of the house is someone who's tempered, someone who's going to give a moderated opinion, say, maybe theory's a little unclear about this. I'm going to say that far more likely to be close to the general scientific consensus. Look, juries can make arguments about lawyers can make arguments about what they want to with regard to expert testimony. It's usually not the case that expert testimony is the sole deciding factor in a case. What we tell you is when you're going to have a case that has expert testimony, you want to make sure you get someone who's very, very close to the scientific mainstream. The second argument I want to give you today, though, is that this is going to fix two important disparities inherent in the legal system. The first is this disparity between the wealthy and the poor. And this is a pretty simple argument, I think, that both sides now can call an expert. That is, if I'm a poor defendant, if I'm a public defender, then I can actually still have access to meaningful expert testimony that'll prove my side. I think this is really, really important at the point where now, juries are bad at evaluating claims between two competing experts, but juries are even worse at accessing truth when they only hear one view. That's exactly when they're likely to put the most credence on it, but still when you're likely to have an expert who's very biased in favor of one side, rather than have an impartial third-party observer whose will and appointment is determined by an impartial third party like the judiciary rather than the executive. And the second disparity we think is fixed is the disparity between states and defendants. That is, a lot of times, like, crime labs actually do work directly for the prosecutors because they work directly with the cops. So that is, DNA evidence is coming from the prosecutor's office, and we have no way of evaluating that truth because defendants just don't have access to the information. So I think this is going to fix, in some ways, the disparity between the state and defendants, in addition to the disparity between the rich and the poor. I think the state and defendants argument also ties into this, insofar as the state has nearly infinite wealth to tap compared to an individual defendant. On these grounds, we're very proud to propose.
I thank the Prime Minister for his remarks and call upon the Leader of the Opposition to deliver an 8-minute speech deconstructing the government's case.
You're here.
All right. Well, thank you, Mr. Wansley, for an excellent case. Thank you to Matt. It's been a great tournament. And thank you to members of our most august House. Particularly our film crew. It's great to be filmed twice in one term. That has never happened. So I have a couple of independent points that I think in a lot of cases are just going to be observations. They're going to be things that I'm going to just need to you to take with a grain of salt and trust me on. But then I'm going to go case-side and deconstruct a lot of the arguments brought forward, because I think, well-intended, this case does raise some very significant problems for the judicial system if we hope for it to continue to process cases in a way that leads to a net just outcome. So the first thing that I would begin with is that sometimes experts disagree, all right? And that sometimes it is fundamentally necessary to have more than one expert examine the same body of facts, because sometimes they will draw different conclusions, all right? Now, obviously, the two examples where this isn't the case are the most clean-cut, like DNA and ballistics. Though ballistics is somewhat more ambiguous. Like, either your blood was on the scene of the crime or it wasn't. And there aren't too many DNA experts who are going to disagree on that. But for fuzzy cases, things that are a little more abstract, like even the firing of a bullet, or whether or not someone could be determined to be criminally insane based on their mental history, or based on the stress that they'd undergone prior to that moment, you're going to need to bring in more than one person, because very, very smart people will disagree. And I think that it's really important to put as much information in front of the jury as possible. So here's why their system doesn't meet these kinds of cases. Because if you only have one person that you can ask these questions of, that person's decision, even if it lies far outside what would be the scientific consensus, if you could ask, like, say, 10 psychiatrists or 10 ballistics experts, that is all you have to go on. That's the only information that gets in front of the jury. And because there is only one expert, and it's now the state-appointed, endorsed, this is the guy we're going to believe no matter what he says, that testimony is given a huge amount of weight by the jury. Which means that the right to meaningfully cross-examine that expert is significantly harmed for whoever is hurt by that person's testimony. Now, that might be the prosecution, that might be the defense. I'm willing to bet that more often than not, it's going to be the defense that is hurt by this. But the point is that we would argue more information getting in front of juries is better, because we think that they can meaningfully distinguish between someone who's a crackpot and someone who actually has reasons to believe. And sometimes, particularly in ambiguous cases, people disagree. And this isn't a small case, right? This isn't a fringe example. Like, a lot of times determining whether or not someone was criminally insane at the moment that they committed a crime will determine whether or not they're capable of getting capital punishment. So, like, lives hang in the balance on this potential question. I think that's really important. The second thing that I would talk about is that on their side of the house, because you have this list of officially endorsed state experts, you're going to rule out new theories. Now, because they didn't lay out any criteria for how you would get on the list, and I'll get to that on case, I think that's a substantive problem as well, is he admitted in a point of information there's going to be some time lag between when a theory is put out there, when it might even be considered generally scientifically credible, and when it will actually get into courtrooms. That's really bad, because it means that people will be clinging to old science, dead dogma, and using that as the determining factor in some cases. Maybe not the determining factor of guilt or innocence, but certainly it could be weighted into the punishment. And it might come down to, guilt or innocence as well. So the deciding factor in these cases will be science, which may have been repudiated, disproven for months, even years, and you won't be able to get new information in front of juries, and I think that's really critical. Whereas in the status quo, you can bring this kind of information out with very little notice, because prosecutors have every incentive to seek out the latest research, to find the most credible theories. And even if it hasn't been tested a dozen times and gotten under the state's list of things we're officially willing to believe because our experts tell us that it's true, it's still credible scientific evidence that deserves to be brought into the courtroom. They rule credible evidence out, and whenever you take credible evidence out of the courtroom, I think you hurt the system of justice. You lead to more wrongful convictions and more wrongful acquittals, and we think that's really bad. The third argument that I would make, and this is, again, the one that I sort of foreshadowed at the beginning, just going to have to bear with me with this. We're going to argue juries are smart. That, like, the average person, when put into a situation where they have to determine who's telling them the truth and who's sort of bullshitting, is capable of deducing that. And we think that the reason we have juries in the first place is because we believe that this is true, all right? If he's right, and that juries are so swayed by experts that they can't meaningfully distinguish between good theories and bad theories, then that's a good argument for either not having juries or getting rid of expert testimony in general, all right? Because realize if he's right about that, then their case exacerbates this problem by meaning that people who are so stupid they can't figure out a good theory from a bad theory are only given one theory to weigh, and that's really, really bad. We think that people are smart, they'll be able to figure it out, and I think that the criminal justice system works fairly well in the status quo because we give juries this power and we trust them with that. I'm just willing to continue to trust them with this power. They have just asserted juries can't figure it out. Give me some evidence, show me why juries are so incapable of deducing what's true and what's probably not. And the fourth and the final thing that I want to talk about is plausibly the cost for experts could go up in a huge way, and net increase in the cost of trials on their side of the house, because as long as you have these people on retainer all the time, even if you only pay them by the hour, if you only have one list of people to go to, that could mean that they're more expensive. If you're taking the best people out of their field, you're only going to have the option of having like the most expensive experts. And then on the other hand, if you want to save the state money, you're going to go for the people who are least respected in their field, and that means you're going to have like more bad information in trials. And I think that at the point where people can bring in experts and they don't even have to prove probative value, you're going to have a lot of expert testimony, potentially much more expense for the justice system. Hang on, I'll impact this point and then I'll thank you. The impact of that point is if you spend a hell of a lot more on trials, in general you have less, or in expert testimonies in one trial, you have less money for other trials in general. That could lead to a net harm to the justice system. We think that's significant, sure.
I mean, I'm not really worried about this. We can make a pretty big list. We could have like local experts from local universities. Like, okay, we could use state universities.
All right, so they're going to get up an MG and find ways to mitigate the cost point. I don't think it's a huge point in this round. I wanted to put it out there. So going case side. The first thing that they talked about was more accurate verdicts, and they said they would get more accurate verdicts for a couple of reasons. They said, first of all, that the adversarial process has limits, and the major limit to it is that juries are incapable of determining good theory from bad theory. Cross upon my off-case point that I think we trust juries with this power, and if we didn't, if there really was reason to believe that juries are utterly incapable of determining good theory from bad theory, then they exacerbate that problem on their side of the house by only giving them one theory to be exposed to. And they said, look, people have an incentive to bring the least extreme, or in the status quo, people have an incentive to bring the most extreme experts. I don't think that's true. I think if you're a prosecutor and you had a choice between a crackpot and someone you knew had credibility, every single time you would try and bring in the person with credibility. So there's no necessary reason to believe that there's any incentive to bring in wild theories in the status quo. And particularly if it's going to lose you the case anyway, or if you don't think it's going to injure the case, like why spend the money on it? So I don't think that's a huge problem. The next thing that they talk about is that experts that don't, that have credentials, like the people who are most likely to bring experts are people who are just trying to bolster weak cases. I think this is an assertion that he gave us no evidence to believe. I think that like expert testimony is actually really common. There's a thing called the CSI effect, where like prosecutors will bring in DNA testimony just because juries expect to see it. So it's not just to bolster weak cases; it's to bolster every case, and it's usually because like who fired a gun when and where the bullet went is really, really relevant to determining the outcome of like a murder or something like that. So I don't think that's true. The next thing he said is that experts are beholden to the people that are paying them. So if a prosecutor hires an expert, he's going to slant his testimony in favor of the prosecution. I think that might be true to a degree in some cases. I don't think it's a significant harm, and here's why. First of all, I think that people, because they're conscious of their professional standing, are going to try and stay within the realms of good science so that once they leave the courtroom, they're still respected amongst their peers in the scientific community. Second, I think that just because they're being paid by the prosecutor's office doesn't mean they're willing to compromise their research, because the short-term amount of money they make by being an expert is a hell of a lot less interesting to them than the money they can make by being a credible scientist. Third, we have perjury protection, so if someone really is stretching the truth and like lying under oath, we can prosecute them for that. And fourth, juries, and this is the most important thing, juries know this. Because if you're an expert witness for the state, nobody knows who pays your salary. If you're an expert witness for the prosecution, that means that they know every word that comes out of your mouth has been at least groomed by the prosecutor because he thinks it's going to help your case. So even if he's right about experts being beholden, that doesn't matter because juries are aware of that when these experts come before the court. Next thing they talk about is different positions. I didn't write anything under this, so I'll just go to the next point. Sorry about that. Next thing he talks about that I wrote down was that experts are going to be political. That experts have an incentive to like slant their views in order to get hired by prosecutors who like really hate the death penalty or something like this. I think that if this is true and it's a substantive harm, I'm not sure that it is. They vastly worsen this problem on their side of the house, because now your incentive isn't just to like strengthen your views so that prosecutor A over prosecutor B is more likely to call you to trial. You have to strengthen your views to get on the state list, and presumably the people who control the state list are fewer in number than there are prosecutors in the country. So you have a far greater incentive to slant your research to political biases of the people who might hire you. I think that's really important. The next thing they talked about is you're going to bring in fringe views, and these fringe views will be given equal weight. Again, I don't think that this is necessarily true. I think juries are smart. Just because there are two experts in the room doesn't mean they're equal. Not all ideas are created equal. Not all experts are created equal. Juries know that. And the final thing he talked about is disparities between the wealthy and the poor, and the prosecutor and the defense. I think that we meaningfully check for this in the status quo by allowing people in the defense to cross-examine the witnesses that the prosecution brings forward and vice versa. And moreover, this is a good argument for giving indigent defendants a facilitated right to expert testimony and allowing public defenders to call experts before the court regardless of the expense as long as it has probative value. There are ways to solve this problem without bringing in less evidence, and that's the bottom line we're proud to oppose.
I thank the Leader of Opposition for his remarks and call upon the Member of Government to deliver an 8-minute speech reconstructing the government.
You're here.
Thank you, Madam Chief, and of course, many members of the audience. I hope this is an interesting round for you. I think that was a great brought a lot of interesting issues. I'd like to get into those. Let's look at his first argument. Why sometimes experts disagree. And absolutely that's true. We'll recognize that sometimes there's points where experts have different opinions. But the problem is, we'd say that juries can't meaningfully evaluate these sorts of differences, right? When there are issues of sort of scientific contention, I know I certainly can't evaluate those distinctions. It's not that juries are stupid, right? I'm sure they're very smart. I'm sure they're very well-meaning. But even like a college student can't actually meaningfully evaluate these sorts of distinctions, can't actually meaningfully evaluate these sorts of differences. Moreover, they actually block scientists from juries, right? Because they don't want people who can meaningfully evaluate these sorts of distinctions. And so I think it's actually very fair to say that juries won't be able to sort of evaluate the differences. So then what's the alternative here? On our side of the house, we have sort of a scientific community, choose these experts so they know that these experts represent the overall community. So we know they're at least more to the mainstream. On their side of the house, when there's a disagreement, it's very possible that you have some extreme expert advocating the wrong side of this disagreement. Moreover, we say that in our side of the house, because it's non-adversarial, experts are more likely to give the nuance of the issue, right? Because they no longer feel beholden to the prosecution, because they no longer have the sort of difficult position of the advocate, because that no longer exists, they're more likely to explore the actual nuance of the issue, which means that if there is disagreement, they can explain it to a jury instead of just advocating one view. Not right now, actually. Let's go to their second argument. Second argument is sort of a mixture of the first, talks about new theories. I think this process can actually happen really quickly. If these new theories are accepted within the mainstream scientific community, then they can actually be brought, experts will believe in them, right? But if they're so fringe, if they're so radical that mainstream scientists are not believing in them, I'm not sure we should introduce them into the courtroom, especially because juries don't feel to meaningfully evaluate their newness, meaningfully evaluate just how radical they are, right? If it's a new theory and it's good, then the rest of the scientific community will also believe in it. I don't think there's this huge lag that he talks about. Let's go to his third argument. He talks about why juries are smart. Absolutely. I'm not going to just trash juries here. That's not my point here. They're smart, they're well-meaning, they're doing a good service for society. But our point is, even if you're smart, you might not be able to evaluate scientific distinctions between an issue, right? Psychological nuances, things like that. They just can't meaningfully evaluate these things. So when you have two experts offering contrasting views, I don't know that one expert represents the mainstream scientific community and the other is only a fringe idea. I don't really know how to evaluate that. Sure.
Okay, if you're an expert witness and you represent the fringe, and I'm the prosecutor, and your testimony is my case, can't I say how many scientists agree with you? Like, would you consider yourself inside the scientific mainstream?
But I'm not sure that's powerful. But I don't think it solves the problem to the extent that we do, right? Sure, you can ask that question, but what they're going to say on their side of the house is actually say, I am right, the majority is wrong. They're going to cast themselves as the scientist who's actually right, as opposed to the dumb majority, right? Especially when juries can't actually look at the scientific evidence because they can't evaluate these sort of scientific nuances. They can't evaluate these sorts of claims effectively. That's why we should sort of outsource this idea to the scientific community and allow them to choose experts. His last argument talks about the cost for experts, and I'd like to mitigate this quickly. I think it's sort of a side issue around, right? You can have sort of like a sort of big list of people who represent the scientific mainstream, who are approved by the sort of scientific community, and outside this list would be the people who are extreme, right? The people who don't hold scientific viewpoints, things like that. This list can actually be pretty effective without just being like Greg Mankiw on economics and something like that. Moreover, I think a lot of people do that at their goodwill. My mom does tell these cases at her goodwill. I think it's actually pretty fine. Let's go to the first argument of the upside of the case. It talks about more accurate verdicts. I think this is pretty critical. His first response is that juries are not stupid. I've already responded to that. And so the problem is when you have two competing factual assertions, this happens to debate all the time. And good debaters are very good at lying. Why? Because judges don't really know what's going on, right? They can't look in an almanac and be like, oh, this is actually true. They can't look in the most recent economists, and hopefully judges know about this. But a lot of times you get caught where debaters are just straight up lying. Sure.
Okay, if I'm a debater and I'm lying around and someone does look it up in an almanac, then my credibility is shot for the rest of the tournament. Similarly, wouldn't you agree that experts who lie or stretch the truth or give bad testimony are going to be trashed in the scientific community? Don't they have every incentive to stay within their research on the stand?
I'll actually respond to that later, but I think lying debaters do really well on the circuit. References wrong. But I'll respond to the specific argument later. Let's talk about why attorneys with weak cases are more likely to use evidence. He says it's just an assertion. And absolutely, there are some cases where an evidence, an expert is doing something for a case that's already strong. But a lot of cases, when an attorney has no other case, he looks to the expert to sort of bolster it in some way. And when he looks to that expert, you guarantee it's going to be a weak expert, right? Because it's not going to be someone who represents the mainstream. Instead, it's going to be a fringe view who's like, all right, I found this one guy who agrees with me. I'm checking you guys. I found this one guy who agrees with me. I'm going to get him on the stand because I have nothing else to lose. So right, there are some legitimate expert expert witnesses, but there's also this strange problem. Like when attorneys have weak cases, they're always going to look at the expert. Not right now. We told you that like these experts are sort of psychologically beholden to lawyers. And I think it's actually really critical. You've been called and paid by the lawyer who wants you to represent them. And so you might actually be willing and maybe sort of find yourself psychologically, subtly fudging the differences. He says you can't perjure and things like that. That's fine. But I think it's actually more subtle than that. You just might find yourself advocating for them instead of providing a more objective expert opinion. And I think that's actually really, really critical. He says like there's a problem with your own professional reputation. My first response is that the way their system occurs, there is a huge incentive for professional experts. This happens a lot where experts just make money off of being experts and doing nothing else. And so if your professional reputation is just giving really weird fringe views in court, you actually can improve your reputation and get more funds through being a professional expert. But second of all, I don't think the scientific community is evaluating every single case, right? And unless you're some huge guy, if you're just sort of a regular scientist, it's very easy for you to sort of give a viewpoint without that directly contradicting your research. But third, I tell you it's not always something that's absolute fact. It's more subtle. It's more how you're phrasing things. The sort of specific wording you use, how you sort of give credence to other competing views. Because that's true, I don't think it's the case that it's going to destroy our research. Instead, I think it's just going to subtly influence the jury in one way or the other, which we think is bad, right? Because juries can't meaningfully evaluate these sorts of scientific distinctions, and so it's always going to be based off of sort of confidence or charisma. Why do lying debaters win all the time? Because they're really, really confident, and because they have really good rhetoric. Why will lying scientists win all the time? Because they're really, really confident and they give really, really good rhetoric. I think that happens very obviously in debate rounds all the time, and I think it'll happen here as well. Let's talk about giving too much credence to fringe views. He says that juries are smart, and and they'll be able to figure this out. And, maybe they can sort of figure out the really, really retarded ones, right? The ones that are absolutely stupid. Maybe they can figure that out. But the problem is, they start out with equal footing. They start with sort of equal scientific validity in the jury's mind. And so I think it'll unfairly grant extra position to some sort of scientific theories that shouldn't be granted that much position. The example Wanzi gave you is that a lot of times in child abuse cases, most experts agree that those who are abused can come out much later after the incident and say they've been abused. But it just takes one psychologist to say, actually, unless they admit it right afterwards, they haven't really been abused. It just takes one of those opinions to actually subtly influence the jury in terrible ways that affect meaningful people's lives. Sure, not right now, actually. The next thing says, we worsen the problem because you only get one expert. The problem is, these experts are chosen by a community of experts, right? By the sort of scientific community, and so we know that their views are consistent with the scientific mainstream. Instead, on their side of the house, attorneys and also experts have an incentive to go to the extreme, to go to those who most absolutely support their position and are most willing to ignore the nuance of the issue. Because that's true, on their side of the house, they're going to get much less nuanced analysis, much less truth, and instead just sort of strange scientific blinding sold to the jury. I think that's absolutely bad. Let's go to the second argument that talks about disparities. His first argument says that you can cross-examine witnesses and this can solve the problem. But it's obvious that that's not completely true. If there's only one witness and he's completely extreme and he's completely wrong, it's hard to actually prove that without a competing witness. On our side of the house, when you have a good witness, a good expert witness who's actually sort of verified by the scientific community, you don't have that problem. His second response is, I think, actually a case he runs about sort of subsidizing expert witnesses. The problem is, there will obviously be sort of a rich-poor disparity in terms of rich people can pay for good witnesses, while the state can only pay for this, for sort of the public defender analogy. Yeah. In our case, we can equalize that because you're drawing from the same pool of experts, and so I don't think we can fight that problem as hardly as they do. And because that's true, we're glad you proposed. Here it is.
I thank the member of government for his remarks. Call upon the member of the opposition to deliver the final constructive proceed 8 minutes.
Here it is. You're here.
Thank you very much, Madam Speaker. I basically give my philosophy through Brendan's first main point because I think it actually wins us the case right out front. So I'm going to spend a little bit of time on this. He says there are two types of expert testimony, one that everyone will agree on and one that a lot of people disagree on. And both are really important in a lot of court Let's think about the first, DNA evidence. Everyone will agree on it. Maybe one side will bring it up, maybe the other will too, and it's not really going to be a big deal. Either way, you're going to get a lot of the same information. But let's talk about the other one, where experts clearly can disagree on an issue, right? So child psychology, or I don't know about child psychology, but just psychology in general, right? There's a lot of debating issues about when a person is mentally capable of making a decision, what's a rational decision, when somebody is mentally retarded, so you can count that as a murder crime, or whether you have to count it as manslaughter or something like that. There's lots of competing viewpoints on these issues, right? So when we have a competing viewpoint, what's the best thing to do? Is the best thing to do to roll the dice and get one viewpoint out there, get one expert who has one particular viewpoint on that issue, and have him speak to the entire jury? Or is it better, even if the jury cannot fully analyze both sides of the house, isn't it better to get two viewpoints out there and let them make the decision, as long as there's conflicting viewpoints? A lot of the time there are a plethora of viewpoints, and we believe on our side of the house that the more evidence you get out there, the better, because the more people they hear, even if they can't analyze it to the utmost perfection, it's still much better to have all that evidence out there. Yeah.
If it's the case that there's so much professional disagreement that there's no right answer, there's no harm on our side of the case because there's no wrong done. But on your side of the case, there are expert witnesses who have a clear incentive to extremize their
No,
view.
there is a huge harm, because even though there's not any one right answer, which is the truth, you're presenting one person as an expert that has all of the right answers. You're saying the state is paying this person to stand up and be the authority of the subject. So exactly what you're doing is you're giving something with no right answer the right answer, and you're doing that by rolling the dice and simply picking some person on an arbitrary basis, which is not just. And he gave a couple of responses to this entire argument, which is that juries cannot evaluate this. But what I'm going to tell you is, first of all, Brendan told you juries are smart. But furthermore, juries are really, really good at telling who's telling the truth, and we trust them with that all the time. The example I'm going to use is this. Juries weren't at the crime scene, right? So they don't know who saw what. But we still allow them to judge the expert testimony, right? Or judge testimony in general, right? You can testify to one thing, I can testify to the other. The jury's job is to decide who's telling the truth. That's actually the job of the jury in a very substantive way. We're just doing the exact same thing here, right? They're not the expert on the crime scene, just like they're not the expert on psychology, but we can still let them choose which viewpoint they want to decide. They get to decide on the evidence. So not only are they smart, but they're particularly good at doing this. This can also come out in cross-examination, right? Maybe the jury doesn't have all the answers to why this scientist is wrong, but I'm willing to bet you that the lawyer is sitting in his courthouse looking at the credibility of the scientist, right? Looking up every single bad thing he's done, every single thing that people disagree with him about, and bringing it up in cross-examination. So the jury might not be able to be like, well, that's not really right because his analysis doesn't match there. But the lawyer is doing that, and he's going to bring all that out, and he's going to expose that to the jury, and they'll be able to take it under the account then. The last thing Brendan says under this is a lot depends on this. So a lot hangs on this expert testimony. We need as much evidence out there. I think I've proven to you why more evidence is better, even if they can't analyze it perfectly, but we're going to trust them to do that. The next thing that Brendan talks to you about is the role of new theories. And he says that, the next thing Brendan talks to you about is that there's a role of new theories, and there's a huge time lag between what really is being discovered and what we would have in the courtroom on their side of the house. And they say that it's not okay to permit it to the courtroom unless everyone believes it. But we believe that that's not true at all, right? If an expert can come up with a really good theory about why this person is crazy and it's believable to the jury, and that cross-examining lawyer can't prove anything to dissuade it, we believe it should be admissible. There is a lack in this sense, and there's no reason not to close it, right? It's a simple appeal to tradition on their side of the house. I think that's bad in a debate round. I think it's also bad in a courtroom. It's not good just to simply say, because this was right in the past, we're going to wait a really long time until the entire scientific community accepts it to establish it as precedent within the courtroom. We don't see why that needs to be the case. We think we can save lives and save a lot of truth on our side of the house, wrongful convictions, and letting people off for no reason. So the last thing Brendan talks to you about, our second class, is that juries are smart. He says that we trust them with a lot, and their reasons would be reasons that we shouldn't have juries in general. And I think I really explicated this very well, because we determined that juries, people, the common man, can find the truth in things. They can decipher whether you're telling the truth by simply your testimony, by judging the words that are coming out of your mouth. But furthermore, we have these things that Brendan speaks about, like cross-examinations, right? We depend on the lawyers to bring out even more truth. So even if the jury can't promote every single nuance within the case, we believe that that's the lawyer's role to expose them to the jury, and then the jury to judge it there. Please.
If cross-examination is so good, then why are you so worried about having only one theory?
Why am I so worried about only having one? Because the idea that there's only one expert, right? You have a state paying and then saying that there's one expert, one authority on the subject. It's the whole predisposition that there's a single answer to a question. Cross-examination only works when there's doubt in the room, when there has to be doubt, when the juries feel like the decision is up to them. As soon as you impose on them the right answer, then they no longer trust themselves and they no longer trust the examination. All they trust is the God that's sitting on the stand testifying. The last thing that Brendan says is the cost is enormous. And they say it's not really that enormous because a lot of people do it out of goodwill. First of all, I don't think a lot of people are doing that out of goodwill. Secondly, I'd like to say that as I pointed out in a point of clarification, they're providing for every single thing, not only for the prosecution, right? So we have the line path, but also the defendant. They put no limits on what you can bring up, except the judicial discretion. I think that it is going to be an enormous cost because you're paying for both sides and you're paying for whatever each side wants. So with my remaining time, I'm going to go case side. I think I'm going to be able to dismantle the rest of what they said. The first thing that they said on their side of the house is that juries can't tell what is right or wrong. I think we've already talked a lot about this, how juries are smart, and juries are particularly good at truth-finding missions, which is basically what this is. You're deciding which person is telling the truth. I've talked about this a lot, and I'll get to it even a little more later down in the case. The next thing that they talked about is that this is only going to, this will provide the most simplistic view, the most traditional view. And Brendan responded to this in saying that the people are already trying to bring in well-respected experts, right? This is a really big point on the case, and I think they win it. They say that they're going to try and bring in the most extreme experts. But what is the problem with that? The problem with that is that testimony relies on credibility, right? And it relies on credibility that the lawyer is going to bring out. So if you bring somebody on the fringes of society, then the other lawyer is going to stand up and be like, isn't it true that 99% of your peers strongly disagree with you? How do you think the jury would judge that? Therefore, you're not going to bring up somebody who 99% of his peers disagree with him. You're going to bring up somebody that's in the middle of the road and has a good viewpoint on this. So we think that because of credibility, we solve for these problems on the whole. And that's what the courtroom's all about. The next thing that we talk about is that they only use it to bolster weak cases. Brendan says, no, we use it all the time. Expert testimony is a really useful thing in the courtroom. In response to this, he says that I don't know, that again, you use it to bolster weak cases, but this isn't a harm at all on our side of the house, right? If they're using, like if you get a really fringe expert to try and bolster a weak case who has no credibility, they're not going to win the case based on that one expert because it's going to come out that he's not telling the truth. So it's not like a ton of people are going to get off because of this. We don't think it's a significant point of the round. The next thing that they talked about is that it's a difficult position for experts to be in. And Brendan gives you a laundry list of reasons why this is not a problem. First, they're conscientious of their professional reputation. Next, they won't compromise their research. Third, perjury can protect us. And lastly, juries can know this. Another thing I just want to add to this laundry list is that it hurts their credibility, right? Even on the witness stand, at the point where they're advocating for the defendant, it hurts your ability to believe them. If you want to be believed on the witness stand, you need to be somebody who's simply appealing to you need to be somebody who seems unbiased in this situation, right? So it hurts your credibility on that witness stand. Furthermore, if you lie in one case, even if you depend on testifying as your profession, no one's going to hire you because it hurt your credibility, and the next cross-examining lawyer is going to bring that out. Isn't it true that you lied or advocated for your proponent in this scenario? Therefore, the jury's not going to believe them, so it'll hurt your career even if it is simply to testify. The last thing that they talk about, one more thing I want to hit on is that they said that they would try and skew their views towards certain interest groups, but you're clearly going to Brendan said that you're clearly going to skew the views towards whatever the state list believes. They brought up the child psychological viewpoint for this. So this is really bad because people will just appeal to the tradition of the state, right? We won't have any scientific advancements because scientists will be skewing their views in order to be well respected by the state to the views that are already held by the state, which we don't think is good for the technological field. The last example they bring up is child psychology, right? So if this new radical view of child psychology and everyone wants to come forward to their parents to tell them that I got raped is introduced in the courtroom, automatically the juries are going to believe that. Automatically that's going to win them the case. No, I don't think so. Because we all have common logic, right? We can all think about how, maybe if I was a child that got raped by my dad when I was 2 years old, I might not want to come out and tell the whole world about it right away. So we all have these predispositions that we're going to challenge these scientific views with. It's not going to always adhere to that. The last thing they talk about is disparity between classes. We have cross-examination, and we can also solve the problems in better ways. And they said we can't afford that. They also said in the PM that the state has unlimited resources and a lot more than both sides. So we're very sorry to propose.
I thank the member of the opposition for his remarks and recall the leader of the opposition to deliver the first rebuttal speech of the round, not to exceed 4 minutes.
You're here.
Thank you, Madam Speaker. Thank you, my partner Matt, for an excellent speech and a great tournament. Thank you to good friends inside government, and again, the members of this most best house. I think that today's debate round comes down to 3 large questions or observations. So the first question that I have is the scientific community in any way a political community? And I think that you have to realize that it is in a lot of ways. That your advancement as a scientist in a lot of ways depends on the respect you get from your peers. Now that's both good and it's bad. Let's go through how that affects the situation that we're talking about today. As Matt observed initially, when it comes to determining legal fact in a trial, you're going to have one of 2 situations. Either something is going to be scientifically unambiguous, that is to say there will be a broad consensus, like yes, this is your blood on the scene of the crime, no DNA expert would disagree, or there won't be that agreement. In a case where something is contentious, we think that it is clearly better to get people from different ends of the scientific spectrum, like people who would have different competing theories on what constitutes legal insanity, or what kind of threshold is necessary for a child to repress a memory. Those kinds of ideas are not necessarily going to be embedded in one person. Because a lot of times advancing in the scientific community means advancing just one theory or one side of a theory. So the state-appointed expert isn't necessarily guaranteed to give a detailed view of the nuance of the dispute. We think that's really meaningful. The next thing that we talked about in terms of scientific community being political community is the emergence of new theories. And we said, look, as long as you have an approval of this, there's going to be a lag time between when something gets scientific credibility and when you allow it into the courtroom. That means in the meantime, you're denying good evidence access, you're denying the jury access to good scientific evidence, and that's really, really terrible. And he says, the member of the government said, well, I don't agree. All right, well, here's a great example. Just 2 weeks ago, they discovered a gene that has a massive, massive link to schizophrenia. So someone with no family history of schizophrenia, but who tested positive for this gene, might have had a psychotic episode, and that might have had might be really, really relevant in the course of a murder trial. Right? If the state-appointed expert says, well, without a family history of schizophrenia, I mean, there's just no reason for me to believe that this person had a psychotic episode, and the defense lawyer can't bring the new evidence in front because his expert, the geneticist who figured this out, isn't on the list, that means that his client is out of luck despite the fact he very well may be innocent. And we think that that's really, really bad. I mean, obviously, who gets on the list is a political decision, and allowing politicians or bureaucrats or even the scientific community to determine who is good enough to go in front of a courtroom is a worse alternative than allowing the prosecutors and the defense to just have at it and let the jury figure out who's telling the truth and who needs to be doubted. The final thing that we talked about was the danger of fringe views. And the nightmare scenario painted by the government is that there is this underclass of wandering madmen in wizard hats who make their living as expert witnesses in show trials. And their entire way of life is based on lying about things that are scientifically dubious. And we need to find a way to keep these people out of the courtroom. First of all, I don't think that this is a legitimate harm, because if there were such a person and he came in front of a jury, you'd be able to figure out pretty quickly that he was such a wandering madman. His wizard hat would probably be a tip-off. And moreover, the experts being beholden to the people that employ them, if that is really the bias, if it's not the obvious hyperbole I was just engaging in, if it's just the issue of bias about who they're beholden to because who cuts their paycheck, that's a problem that they vastly exacerbate on their side of the house, because there's only one witness, there's only one paycheck, and that means that the political incentive to get yourself in front of a trial and slant your research to accomplish that goal is far greater on their side of the house. The second question that I think is important is how persuasive are experts? We said that experts are fairly persuasive in a lot of cases. Like if someone with a degree tells me something is true, I'm inclined to believe it, right? But juries are pretty clever. And juries are pretty clever because they are given the option of seeing different people who also have degrees and who also compete with that person. And remember, I think every prosecutor and every defense lawyer has every incentive to take the most credible theory, or at least the most credible person they can find when they're bringing their scientific expert in front. And not only in front of the jury, and not only that, because of the absence of scientific consensus on some of these things, their case seems to be a good argument for simply letting scientists determine legal fact as opposed to juries, right? If something is so complicated that the average person can never figure it out, why don't we just have a group of scientists say, is the person innocent or guilty, but by the way, he definitely fired the gun and you can't even disagree with that. And finally, we said you have cross-examination, and cross-examination only meaningfully works if, in addition to discrediting one witness, you can bring forward another. That's why cross-examination of just one state witness isn't good enough. So the final point, and because I'm out of time, I'll end it on this, is sort of a philosophical question. I think that's what's at the heart of today's debate case, is what's the best way to arrive at the truth, the right answer? On our side of the house, we say that don't just trust the dead dogma of the state-appointed witness. Allow competition. Allow different views to have their way, and allow reasonable juries in each situation to decide what they think is true and what they think is false. We think competition is a better way to arrive at truth than just handing someone an answer, and for that reason, we're proud to oppose.
I think the opposition and recall the Prime Minister to the final speech of the round and proceed 5 minutes.
Thank you, Madam Speaker. I think it's been a fantastic round. I think courts and juries face easy cases and hard cases, and that's how I'm going to structure this last speech. I want to talk first about hard cases. I think these guys are really worried that we're going to get only one view in hard cases. And I think this is where Jarbo gets his rhetoric, like, if it's so simple, why don't we just let scientists determine the facts? So if everything they say about how lawyers are really savvy with cross-examination, I have no idea why they're worried about getting one view. But moreover, here's the important argument, and here's the argument Joe and I have been making since the beginning. Our experts have incentives to recognize the nuance of the situation. They have the incentive to include new theories, yes, that they will know about because they're experts in the field, because they're beholden solely to subject matter expert committees. Whereas on their side of the house, the experts are beholden to either prosecutors or savvy corporate defense lawyers who can afford to buy out experts. Or not necessarily buy out experts as in bribe, but to find the one expert who honestly believes that they're right. The one expert who honestly believes that tobacco doesn't cause cancer. So look, if you're worried about getting nuance, then our side is the only side that ever presents any nuance. Because on their side of the house, nuance is punished. Why is this? Because all right, what are juries swayed by? Maybe juries are swayed by scientific truth. That's one view. I think juries are swayed by a lot more things. Juries are swayed by appeals to emotion, appeals to ethos, appeals to things other than the objective scientific truth because they just don't know it. Because they just don't know the history of the field. They don't know the technicalities of like the Krebs cycle in medicine or like Newtonian physics within ballistics. Or like the massive history of cases within psychology. Look, I have no idea why we wouldn't get nuance on our side of the house when the expert we bring forward is neither beholden to the prosecution nor the defense. They have no incentive to hide any nuance. So anytime a prosecutor comes up and cross-examines them and says, is there controversy about this in the field, they have every incentive to say yes. Whereas on their side of the house, they have every incentive to say no. Here's the next argument that we thought was really important. These guys consistently told us that juries are good at telling who's lying, but I think this misconstrues our case. Joe and I never got up here and told you that experts are going to lie. We think experts are going to believe their theories. We think they're just wrong. So that is, if I'm an expert, I honestly believe that children will come forward immediately if they're abused. So a jury, like whether or not you think juries are good at detecting people who are lying, juries have no ability to detect whether or not I'm scientifically correct. And I think this undercuts a lot of their offense when they tell you that juries are able to like evaluate competing claims pretty well. It's not that we think juries are dumb. It's that we think they're ill-equipped to judge the scientific truth. It's not that we think they're bad judges of character or bad judges of like who's lying and who's not. It's that they're unable to evaluate complex scientific decisions. That's all we're saying. Look, when it comes down to a matter of scientific truth, juries won't be able to evaluate that. They can evaluate who's lying and who's not. Here's the thing. I think the only other thing they have on their side of the house is this idea that like people lose credibility, but I thought Joe had two smackdown responses. One where Joe told you this isn't like Manchu getting up there and saying communism works. These are much lower scale, so this idea of academic credibility is a little silly. But then I think, again, this is how they've been misconstruing our case all along a little bit, is that this is much more subtle. This is wording. This is not recognizing an opposition that exists to your own theory. This is you espousing a theory that you personally believe, and just maybe like glossing over a little bit of how serious the opposition is. Some of the objections, portraying them in a less favorable light, giving straw man argumentation like that. Or the third alternative is here is someone who's like completely at the fringe anyway, at which point, they're not going to lose any credibility anyway. But let's talk about easy cases. So I think on our side of the house, we are almost never going to get easy cases wrong, where there is a broad-based scientific consensus about what actually would happen. But on their side of the house, there's actually a very good risk you get easy cases wrong. And this is the crucial third argument under our first point, where we told you that in easy cases, your juries might assign equal Bayesian priors to people who they don't have any experience in the field. So it's very difficult to say like, oh look, this guy's really, really fringe within the scientific community. Look, anyone can drop a list of like 100 scientists who think creationism is bunk, or who think creationism is true and evolution is like completely bunk scientifically. And I think this might be enough to persuade some juries who have some self-confirmation bias and want to believe this anyway, or are appealed by the rhetoric of like, oh, the man is wrong, the mainstream scientific opinion is wrong on this. I think there are a lot of ways to persuade juries other than just raw scientific fact, and I think fringe experts on easy cases might be able to get away with this. This is exactly what we were talking about when we talked about lawyers with weak cases are going to be able to seek out experts who agree with them. Look, this wasn't an assertion here. This was just an argument about incentives. If I have a weak case, I need expert testimony to bolster that. If I'm going to go and search until I find the one guy who thinks that children won't come forward right away, I can do that. And then I can portray it as at least a much more equal position than it otherwise would have been. I think when you ask a jury to evaluate whether or not a child's going to come forward, they're not going to do it correctly. They're not going to be able to evaluate the complex psychology because they just are unaware of the complexities of the field. But the last thing I want to talk about briefly, and I think I'm very sad that this is an issue that's dropped out of the round a little bit, is I think we actually do solve two very important disparities within the system. And I think their plan that they sort of like half-assedly assert up here, this other case that apparently they run, about we should like subsidize public defenders' access to expert testimony or something like that. I don't think that's going to solve the problem. Joe told you a really good response to this where he says like, this just creates like you can get like the bad expert if you're a public defender, you can get a sweet expert if you're a savvy corporate defense lawyer or something like that, or if you're a savvy like prosecutor or something like that. I don't think there's a really good way to solve the disparity within the system as it is. Especially this is important because as they tell us, the CSI effect is alive and well, and juries depend a lot on expert testimony. A lot of cases are determined by expert testimony, which makes it all the more important. As we told you, juries are unable, it's difficult for juries to evaluate two different competing claims, but they're even worse at accessing truth when they only get one view that's on the fringe. When you get one view that's beholden to the prosecutor, beholden to savvy corporate defense lawyers. We're very proud of those.